This meeting is being.
Hi, hi, and very good evening. Welcome to CEDE's Vimukta Divas lecture. I am Arslan Ahmed, and I am a student fellow with CEDE. For those of you who are attending one of CEDE's event for the first time, I would like to briefly tell you about us. CEDE was founded in 2021. CEDE was founded in 2021 and is an organization that works towards improving inclusivity and access within the legal field. We do this through direct impact initiatives, capacity buildings, events, and research. In the last 2 years, we have arranged around 200 internships for law students from marginalized communities, apart from a few jobs. We also have a formal collaboration with the University of Windsor in Canada, in which two candidates recommended by us were provided fully funded overseas LLM admission at the university. We also organize and host mentorship and capacity building workshop for the law students from marginalized communities, which includes CV building, research, legal research, and writing application for policy fellowship and foreign university applications. We also try to keep the conversation alive on issues of marginalization through events like today. We are so happy to have you with us for the inaugural edition of the Vimukta Divas discussion. We are so honored to have among us Honorable Justice P.S. Narasimha, Judge, Supreme Court of India, to deliver the Vimukta Divas lecture. But before we request Justice Narasimha to deliver his lecture, let me briefly share what Vimukta Divas is and why it is celebrated. 31st August 2023 marked 71 years since the repeal of Criminal Tribes Act 1871. This act passed by the British colonial state declared several indigenous tribes and backward castes as criminals and put them under continuous surveillance, making their lives impossible. 31st August every day is celebrated as Vimukta Jati's Day in India by communities who declared criminals under the act. And on this day, the Criminal Tribes Act 1871 was repealed and the criminal tribes were denotified. Now, let me formally introduce our guest speaker for today, with Justice Narasimha. Justice Narasimha graduated with triple majors in economics, political science, and public administration from Nizam College, Hyderabad in 1988. He pursued law at the Campus Law Center, Delhi University. Justice Narasimha began his legal practice at the High Court, Civil Court, and tribunals in Hyderabad. Later, he shifted his practice to the Supreme Court. Throughout his career, he appeared in a large number of cases, including several constitutional bench cases before the Supreme Court of India. During this time, he was appointed as the Commission Counsel for the Justice Chinnappa Reddy Commission. He was also a member of the Supreme Court Legal Aid Committee in 2008. He was the member of Legal Aid Committee. In 2008, he was designated as the senior advocate by the Supreme Court, and later in 2014, he was appointed as the additional Solicitor General of India. On 31st August 2021, Justice Narasimha was elevated as the judge of the Supreme Court directly from the bar. Now, without further ado, I would like our guest to please start his lecture. Over to you, Your Lordship.
Thank you very much, Arslan. A very good evening to everyone. Anurag Bhaskar, Disha Vadeka, Avinash Matthews, Deependra, and team LiveLaw. I would like to thank the community for the eradication of discrimination in education and employment, CEDE, for giving me this opportunity. I'm delighted to deliver this lecture on the Vimukta Divas occasion. CEDE, as Arslan has just told us, is a network of lawyers, law firms, judges, and other organizations and individuals who are committed towards reforming Indian legal profession. The community works towards improving the representation of minorities like Dalits, Adivasis, other backward classes, nomadic and denotified tribes, transgender persons, persons with disabilities, and people from Northeast India within the legal profession and judiciary. I take today's lecture as an opportunity to further their conversation on justice for these communities, specifically in the context of and in the light of Vimukta Divas that is celebrated on the 31st of August. As Arslan has said, that this is the importance of the occasion. This day marks the repeal of colonial law called the Criminal Tribes Act, as you all know. This law was enacted in 1871 and it criminalizes the community of people being criminal tribes. Every person who was born in these communities was branded as a criminal and subjected to police verification, arrest, violence based on their birth. The act continued to remain in force even after independence, which we got in 1947, and the establishment of our constitutional republic in 1950. It was repealed only on 31st August 1952, when the so-called criminal tribes were denotified. Vimukta Divas is celebrated as a day of independence, very correctly, by the people belonging to these denotified tribes. In fact, it is for us to celebrate more than them. In today's lecture, what I propose to do is to locate the history of unfreedom and inequality in these communities, faced and discuss the path to justice for them through our constitutional democracy and values. First, I will draw the attention to the historical context of the oppressive law to throw light on how colonial logic worked with the existing caste structure in India to produce a unique form of legal and social disadvantage to these communities. Then I will deal with how our constitutional promise of equality recognizes these historical wrongs and places responsibility on the society and state to correct them. Things don't stop here, because mere constitutional declaration is not sufficient. So we must remember that the legal reform and the guarantee of fundamental rights does not mean that the discrimination faced by them has come to an end. I will discuss the social and legal challenges that these communities continues to face even today. Finally, and as a practical measure, I propose that we must inculcate, to use Dr. Ambedkar's articulation of fraternity, not only in our laws, but more importantly in our society and psychology in particular, as the way forward towards freedom and equality. Let us talk about the act first. To fully understand the origin of the Criminal Tribes Act, we must know two things. First, the criminal activity was seen as a biological and habitual in 19th century Britain. This meant that when a person committed crime, it was attributed to him being born a criminal and being a criminal for his whole life. That imposition of the idea in the Indian context brings me to the second point that I would want to discuss with you all, which is that the British understood India as a collection of castes, where each caste was seen as a homogeneous unit committed to a hereditary occupation. These two assumptions of the British on criminality and caste system underlay the Criminal Tribes Act. Stephens, who is credited for introducing IPC and Evidence Act, reflected on these very assumptions when he introduced the Criminal Tribes Act. And I quote, "When we speak of professional criminals, we mean a tribe whose ancestors were criminals from the time immemorial." That's it seems that's his perception. Who were themselves, that is, their ancestors, were destined by the usage of caste to commit crimes, and whose descendants will be offenders against the law until the whole tribe is exterminated or accounted for in the manner of thugs. This is what his perception was. These words show a deep-rooted bias of the British and the Indian society in criminalizing these communities. With the colonial project of codification and uniformation of law, that a pan-Indian juridical order was established that criminalized several tribes, nomadics, lower caste communities by dubbing them as criminal tribes. The people who are labeled as being born criminal hence faced double discrimination, as they were oppressed and ostracized within the social order of India's caste system, and at the same time by the legal order introduced by the colonial masters. Criminalization was not sudden in the case of these communities. As we know, many of them also participated in the freedom movement. So the history indicates several indigenous communities had revolted against the colonial administration prior to the mutiny of 1857. Even in the mutiny of the 1857, British regime saw indigenous communities as the facilitators of goods and weapons. Consequently, they sought to maintain law and order through extreme measures such as this Criminal Tribes Act. The act contained provisions that empowered local governments to designate any tribe, gang, or class of persons as a criminal tribe if they were, quote, addicted to the systemic commission of non-bailable offenses, unquote. The people of these communities were required to register themselves at the local police station and report their whereabouts on a daily basis. Any travel or change of residence required official permission. These communities faced not just discrimination, but also systemic control over their lives. In 1897, the act was amended, and it was done to make the penalties even more severe because the freedom movement intensified by that time. Children between 4 to 13 years could be separated from their parents and placed in so-called reformatory settlements, which often resembled prisons with barbed wire compounds and restricted freedom. These settlement camps were also sites of forced labor. Lives of Hijra communities in the northwestern province under Part 2 of the Act, the police would maintain a register of transgender persons who were suspected of kidnapping, castration, and sexual activity that was penalized under 377. You all know about that. The police were given powers of surveillance over these Hijra persons who were prohibited from wearing female clothing, performing in public, and children who were taken away from their household. Part 2 of the Act characterized the entire community as criminal and deviant from by virtue of their very own identity. This part was, of course, later on repealed in 1911 itself, which is why Hijra communities are not considered as denotified tribes. However, we must recognize the oppressive effect of this law on them and their persistent association with criminality under Police Act, anti-beggary laws, and anti-sex workers laws, which is prevalent even as of today. The Criminal Tribes Act was entirely repealed in 1952. marking a critical step towards acknowledging the injustice meted out to these communities. The Iyengar Committee, which was constituted to inquire into the law, found that it violated various constitutional promises of equality, liberty, freedom, more than anything, dignity, abolition of untouchability, prohibition of forced labor. Based on these, the committee recommended the repeal of the law. In this way, the Constitution enabled recognition of historical wrongs and provided a language of rights to question the historical injustices. What happens after the advent of the Constitution? The Constitution was formulated as the forward-looking societal blueprint, carving out significant provisions of fundamental rights. These rights uphold the essential principles of freedom and equality of citizens. We should add also dignity, very importantly. The drafters crafted an intricate framework that prioritizes the advancement of scheduled castes, scheduled tribes, and other backward classes. The framework reflected in various constitutional provision is a testament to our collective resolve to build an equitable and harmonious society. The golden triangle of Article 14, 19, and 21 embodies the values of equality, liberty, freedom, life, and dignity of all persons. In no unclear terms, these provisions guarantee equal right to those belonging to marginalized communities. Within the equality provisions, one of the most profound declarations is Article 17, which unequivocally abolishes practice of untouchability. Article 46 serves as a beacon of hope, charging the state with the duty to provide special attention to the educational and economic advancement of these marginalized communities. This mandate is aimed to shield them from the clutches of social injustices and exploitation that have hindered their progress for far too long. 15.2, Article 15.2 of the Constitution embodies a fundamental principle of equality of non-discrimination. This provision ensures that no citizen is subject to any form of discrimination based solely on factors of religion, race, caste, sex, place of birth, or their intersections. 15.4 lays down a clear roadmap for their progress by providing specific provisions for their advancement. 16.4, of course, provides for the affirmative action for them in public employment, and it is a facet of the fundamental right itself. And then we have Article 23 and 24, addressing human trafficking, forced labor, child labor, hold particular significance to denotified tribes. So these are not articles which are just given as a protection, but definitely these are articles which are intended to inure to the direct benefit of these denotified tribes. They reiterate our commitment to safeguard their rights and dignity. We must, however, be cautious of not mistaking that the guarantees of these rights being and automatically translate to a change in the material conditions of these societies. These are constitutional declarations. It is the obligation of the constitutional authorities, therefore, to translate our constitutional promise to actually the reality, whatever has been thought of, believed, and put forth in the Constitution. In an unequal society, the authorities are under an active obligation to prevent any form of discrimination and reduce inequalities. It cannot be an excuse for the authorities to say that the society is unequal and that they are performing their role naturally. Having read the constitutional mandate, I am now slightly focusing on those who are to implement the provisions of the Constitution. That is why I am mentioning to you about the obligations that have been placed. In an unequal world, staying neutral amounts to leaving the weaker and the oppressed in their situation. In that sense, authority is not performing their roles. That's what I'm saying, not performing their roles and responsibilities amount to perpetuation of these inequalities. It is only through the substantive efforts of our legislature, executive and judiciary that the spirit of the Constitution is entrenched in our society. It is therefore not merely the institutions that we are talking about. That's the reason why the last concluding speech of Ambedkar at the end of the Constituent Assembly debate becomes very, very important for us to remember. He said, however good a constitution may be, it is sure turn out to bad because those who are called to work it happen to be a bad lot. However bad a constitution may be, it may turn out to be good if those who are called upon to work it happen to be a good lot. So therefore, there is a great amount of responsibility on those who are occupying the constitutional positions, and not merely constitutional positions, the positions thereafter in the governance. Does it really stop there? Is it merely the persons who are in constitutional position and also those who are in governance is the question. My speech today says that we must travel beyond that. Let me, before touching upon that, deal with the constitutional safeguards in the context of denotified tribes. Our lawmakers and political leaders at the time of independence envisaged affirmative action and reservations as compensatory discrimination that is essential to undo the historical wrong faced by marginalized communities to uplift them to an equal status as the majority. Social welfare also played a significant role in the development of these communities. The Iyengar Committee that recommended the repeal of the law also placed responsibility on the central and state governments to provide welfare to the denotified tribes. In terms of the constitutional protection, however, the cause of denotified tribes did not extensively feature in the deliberations and debates in the Constituent Assembly. The oppression and violence faced by these communities was brought up largely in the context of Article 19(1)(d), which guarantees the right to freedom of movement. H.J. Khandekar, one of our constitutional fathers, he was the only assembly member who brought up this cause in the assembly debates. He stated that the fundamental right to freedom of movement is necessary to fight against the restrictions placed on criminal tribes under the Act. So we never knew that, and we thought it's a general right of 19(1), which is inuring to the benefit of all of us. But then it really had a direct impact. And that's what our constitutional, one of our members of the assembly has said, that it will inure to the benefit of these communities who were otherwise restricted because they were to report regularly, even after the repeal. But then these are the constitutional guarantees which will definitely, which had inured and had an effect on their lives. However, the caste-based disadvantage faced by these communities was not explicitly addressed in the discussions on equality provisions. These communities instead received the benefits of affirmative action by being included in the list of scheduled caste, scheduled tribes, and other backward communities. So what then are the constitutional contemporary challenges that we are going to face? We divided this into a couple of specific instances. One challenge is the lack of consistency, which I say that inconsistent recognition while being included within the SC/ST list extends the benefit of equality provisions to these communities. The challenge of classification adds another layer of complexity to their struggle. Although some denotified tribes subgroups are included in the list of scheduled caste and scheduled tribes, the lack of uniformity across states creates inconsistency. This lack of consistency has led to anomalies where tribes are categorized differently in different regions. For instance, like Fanse Pandits, Pardis are recognized as scheduled tribes in Maharashtra. Their counterparts, the Haran Saikaris and Goan Pardis, are designated as scheduled or Vimukti Jatis and nomadic tribes. Such inconsistencies underscore the urgency to establish some kind of a coherent and uniform classification system that ensures equitable treatment across the nation. It has also led to enormous amount of litigation, these inconsistency. Maybe the time has come for us to answer these. The lack of uniform approach in their administrative classification also ends up excluding them from using the framework of other beneficial legislations like the SCST Atrocities Act of 1989 to report against acts of oppression. The absence of specific safeguards weakens their ability to combat human rights violations effectively. The Bhikkhu Ramji Idate report of the National Commission for Denotified Nomadic and Semi-nomadic tribes took note of this situation and recommends the separate and explicit exclusion of denotified and nomadic tribes in the SCST Act and within constitutional safeguards. That difference being one aspect of it, another challenge is about the disproportionate criminalization. These legal protective measures are essential because the social stigma against these community remain deeply ingrained despite the repeal of the act. The criminal tag continues to haunt them, perpetuating a cycle of bias and discrimination. This social stigma has legal repercussions when we note that some criminal laws are still disproportionately used to target members of these communities. The Habitual Offenders Act was introduced in 1952 as a substitute to the Criminal Tribes Act. While many provisions regarding restriction of the movement, registration of habitual offenders, police surveillance continue, the key difference was that the Habitual Offenders Act did not associate criminality with certain communities, but with individuals. However, the individuals who were labeled as habitual offenders largely hailed from denotified tribes. There is also lack of common definition of who is a habitual offender. And police manuals in certain states still define a habitual offender with reference to caste of the person. The police continue to formally and informally administer the law with the assumption that members belonging to these communities are inherently criminal. Even other laws such as the Wildlife Protection Act, the Indian Forest Act, Prevention of Cruelty to Animals Act, Anti-Beggars Act are deployed in a rather discriminatory fashion. These are practical problems. The third aspect, which is again a matter of challenge for us, relate to the social stigma in education and employment. Beyond these laws, denotified tribes also face discrimination in education and employment. The Iyengar Committee noted that employers refuse to employ persons belonging to denotified tribes as they perceive them to be of a criminal nature. Educational journey of denotified tribes is also fraught with pervasive discrimination. A report indicates that within the walls of educational institutions, students from denotified tribes often find themselves marginalized, considered to be backbenchers and subject to neglect from teachers. Their peers further exacerbate their struggles by branding them as unintelligent perpetuating stereotypes that hinder their academic progress. This critical issue underscores the imperative need for comprehensive sensitization programs amongst educators and students alike. Very important aspect is an examination of the educational status of denotified tribes show that about 61% of their members are illiterate. And this is this is from a report which is as late as 2017. The said part of the schooling is that there are numerous children from denotified tribes who drop out of schools and colleges every year. One of the major factors for dropout is that absence of identity certificates deprive the children of denotified tribes from getting scholarship. Therefore, they do not get encouragement to send their children to schools and colleges. While education holds the promise of transformation, barriers like social discrimination, poverty, and social oppression impede their children's access to learning. What is the way forward? We have seen the repeal of the act. We have seen the constitutional promise. We have also seen the new statutory regimes. We have also seen the rules, regulations establishing and formulating and creating an entire regime of laws and beneficial legislations and regulations. But then it hasn't fully really worked. There is something more that we need to do. I think it is not merely in laws. There is something else which seems to be more fundamental and which goes beyond the letter, beyond laws. It's in the attitude, it's in the beliefs, it's in our habits, it's in our approach. I think I'll take cue from what Ambedkar has said. From these accounts, we can see that the problem is not only a legal one, but more of a social and psychological one. It is therefore imperative for us to move beyond the realm of legal protections and rights in seeking to address the issue faced by marginalized communities. The constitutional authorities cannot work in isolation. Citizens must play an important role in ending social discrimination and holding the state accountable to its promise of equality and uplifting. A higher obligation, I think, is on the communities who have had the largest benefit with no semblance of any of these trappings which the marginalized communities have faced. So therefore, biggest responsibility, if we are talking about now not on the obligation of a state, but if we are now talking about the obligation of general citizenry, then it must be of those who got the best benefit all through without any kind of a hindrance. Let us recall the words of Ambedkar, which is a little longer quote, but it's a very important quote, which I thought I must read the whole of it. And it is in these words, he underscores the importance of social democracy as being necessary for achieving our constitutional vision. I will read this, though it is longer, please bear with me. We must make our political democracy a social democracy as well. Political democracy cannot last unless there lies at the base of it a social democracy. What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity as the principles of law. These principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. They form a union of trinity, in the sense that to divorce one from the other is to defeat the very purpose of democracy. Liberty cannot be divorced from equality. Equality cannot be divorced from liberty, nor can liberty and equality be divorced from fraternity. Without equality, liberty would produce the supremacy of few over the many. Equality without liberty would kill individual initiative. Without fraternity, Liberty, equality cannot become a natural course of things. It would require a constable to enforce them. So, therefore, what he's talking about is the belief and the trust that you have in these three Trinity, and have complete confidence and live with that fraternity. We must begin by acknowledging the fact that there is complete absence of two things in Indian society. One of these is equality. On the social plane, we have in India a society based on the principle of graded inequality, which elevation of some of the degraded to others. On the economic plane, we have a society in which there are some who are immense wealth as against many of those who live in abject poverty. On the 26th of January 1950, he says, we are going to enter into a life of contradictions. In politics, we will have equality, and in social and economic life, we will have inequality. In politics, we will be recognizing the principle of one man, one vote, and one value. In our social and economic life, we shall, by reason of our social and economic structure, continue to deny the principle of one man, one value. We should test ourselves how far we have achieved and gained the situation of one man, one value, one citizen, one person, one value, so to say. How long shall we continue to live this life of contradiction? How long shall we continue to deny equality in our social and economic life? If we continue to deny it for long, we will do so only by putting our political democracy in peril. We must remove these contradictions at the earliest possible moment, or else those who suffer from inequality will blow up the structure of political democracy which the assembly has so laboriously built up. Unquote. In Dr. Ambedkar's articulation, fraternity is what enables the materialization of a society of liberty and social and economic equality. It is only when fraternity becomes a way of life that the conflict of liberty and equality can be resolved as accommodation, inclusion, and cooperation with the needs of disadvantaged communities become socially valuable. Dr. Ambedkar's understands fraternity as a sense of common brotherhood of all Indians, if Indians being one people. It is the principle which gives unity and solidarity to social life. It is only through this sentiment of mutuality, unity, sentiment, I emphasize on that, sentiment, mutuality, unity, oneness, brotherhood, that our fundamental rights will become safeguards. See, the sentiment is something which comes out of your strong belief. So unless we believe in that and move forward with that belief, the constitution and legal infrastructure, which are of course so very necessary, will not attain its completion till the psychological and intention marry it and merge it together and give an absolute and a total effect to what we believe. But we must not mistake unity and solidarity to mean sameness or homogeneity. Our idea of fraternity must not be at the cost of diversity and acceptance of diversity. Rather, fraternity must be the foundation for equality of those who deviate or are different from the majority. Marginalized citizens must be united into majority, not through demands of assimilation into the mainstream, but through access to institutional and structural remedies that redress the disadvantage suffered by them and allow them to maintain their difference, thereby fostering values of plurality and multiculturalism. Such an understanding of fraternity must be socially and psychologically inculcated in our country. Dr. Ambedkar was not only influential in drafting fundamental rights, but he also acknowledged that they must be protected by social and moral conscience of the society. If social conscience is such that it is prepared to recognize the rights which law proposes to enact, rights will be safe and secure. But if fundamental rights are opposed by the community, no law, no parliament, no judiciary can guarantee them in the real sense of the word. Our social and psychological attitude must change from one of discrimination, stigma, and exclusion to equality and inclusion. This change is possible through feeling of fraternity that Ambedkar has again characterized as love. In a letter which he has written to Thakur in 1932, he wrote, "The touchables and untouchables cannot be held together by law. The only thing that can hold them together is love. Outside the family, justice alone, in my opinion, can open the possibility of love, and it should be the duty of Anti-Untouchability League to see that the touchable does, or failing that, is made to justice to the untouchable." Very beautiful letter that he has written. Drawing from this idea of fraternity, I propose that communities who have been oppressed need to be treated with a sense of institutional empathy. Where does the burden lie? It's not with them, it's with those who are outside those. A very heavy burden on them. It is their obligation to treat them with empathy, to take an extra mile, to extra step. Empathy, at the same time, by those in power, should not turn into a paternalistic or a savior approach. That is to say, we must understand the issue and take into consideration the struggles of marginalized communities rather than impose our own worldview. First of all, members of marginalized communities should not only be treated as someone who needs saving, we must treat them as equal citizens who are conscious of what they need. Secondly, we must not stop at merely recognizing the problem. We must take active steps to question even our own privileges. Very, very important. Do we need to take and enjoy that additional extra? These are the questions that we need to ask. And to poetically say, make dignified room for those who were kept out of houses. Within the legal profession itself, we all have much work to do to ensure better access and presentation of marginalized communities at par with majority. A report of the Bar Association highlights the barriers faced by individuals belonging to Dalit community in entering the profession. Such barriers are also faced by other minorities like women, persons with disabilities, Adivasis, OBCs, denotified tribes, and gender and sexual minorities. Therefore, in the legal fraternity, we must create spaces for students and professionals from marginalized communities. We must adopt steps to have adequate representation of marginalized communities in the bar and the bench. That's why I want to, at this very stage, congratulate the very imaginative way in which CEDE was constituted. These are the steps that I'm talking in this particular speech, today's speech. That additional step, that extra mile needs to be taken. It's by not merely providing an individual benefit or making space, it is in a way institutionalized by creating CEDE. And it is in that manner that we need to proceed further. Individuals, institutions, those who are in firms, those who are in startups, whatever it may be, that little extra step need to be taken. And it's my suggestion that every senior advocate should recruit and mentor at least one member from the marginalized communities in their chambers. However, I must add a caveat that such mentoring needs to be accompanied by very, very important dignity and patience. Patience is a very important word. Uh, as a routine or as an obligation that, yes, we need to do it, you take it and then uh, forget about it, or don't remind yourself that somebody has been taken in, and therefore that little extra effort continues to be made, requires some amount of patience. So that patience is again important, or else it will have a negative effect. So one has to be very, very careful about it. It should not be done only to resemble tokenism, is what I'm saying, but rather a humanist approach is needed. This practice can even be institutionalized through regulations of the Bar Council of India. Till such practices are institutionalized, voluntary acts of inclusion by senior members of the bar can lead to major change, as young professionals from marginalized community whom we mentor today may become successful professionals of the future, who may even change the world. At the Supreme Court level, we have tried to do by adopting diversity clause in the new scheme that we have introduced for recruiting law clerks. We need to make efforts to make the legal profession inclusive. Statistics show that out of only 80 out of 4,443 who have applied for law clerk research associate examination conducted in the recent examination of 2003 were scheduled tribes. The proof of the pudding I'm placing before all of you. I will repeat this. 4,443 applications, only 80 of them belong to scheduled tribes. That's not even 2%. This shows that even at the stage of applications, we are not able to reach the scheduled tribes. This is a systemic problem. We must make active efforts to ensure that the law does not remain a profession of only certain communities who have been historically dominant and power controlling. By taking active efforts, I emphasize that active efforts, we will not only recognize the social problems, but also create structures of justice for marginalized. Unequal access to resources and opportunities has kept these oppressed communities trapped in a cycle of marginalization and oppression that is difficult to break. It is important now more than ever to speak and, more importantly, act on the issues that have contributed towards alienation and oppression of the historically marginalized communities. After the independence and the adoption of the Constitution, the marginalized communities in India choose to show faith in the constitutional framework despite facing continuous challenges and discrimination. Only when those in power, those and also those not in power, but are sufficiently endowed, make active steps to remove the barriers of injustice, that the marginalized community shall retain their faith in the constitutional justice system. With this, I thank CEDE, all the founders, members who are actively associated with CEDE, and team LiveLaw. And I thank all the audience, though it is offline. I thank you for patiently listening to me and letting me share my thoughts, having spent so many years as a lawyer and also a few years as a judge. Thank you very much. Thank you very much.
Before moving forward to a vote of thanks, I would like to invite our co-founder, Disha Wadekar.
Yeah, Justice, I mean, I'm just speechless. You've given so much direction and purpose to the legal community. There's so much that we need to do as a community. And I think you've emphasized on just the right things that we need to do. And you've given us a vision to look forward to as a community. I'm really overwhelmed with this speech, this lecture. But most importantly, I think your emphasis on not just a very legalist approach, but a more structural approach, a community approach towards justice in the truest sense. I think that is something that I personally would take away from this. But thank you so much. Thank you so much for doing this. And I'm sure that many more conversations on justice for denotified communities need to happen. And this is just the beginning, but what a beginning and what a start for CEDE and LiveLaw. Thank you. Thank you so much.
Thank you. Thank you very much.
Thank you, Disha. Good evening, everyone. I'm Dipendra Suri, student fellow at CEDE. On behalf of CEDE, I would like to thank Honorable Justice P.S. Narasimha for taking out time from his busy schedule and for delivering such an insightful lecture. His powerful words will definitely make an impact on society. I want to take this opportunity to thank our co-founder, Disha Wadekar, Avinash Matthew, and Anurag, who started the initiative of CEDE in 2021. Thank you, LiveLaw team, for always providing us with their platform. The support the LiveLaw team has been very helpful and facilitative for the event organized by CEDE. Thank you, Hamsadini and Arsalan, our student fellow at CEDE. Lastly, I want to thank our empaneled network of lawyers and professionals for providing internship opportunities and support to CEDE students. If anyone wishes to join our empaneled network, please visit our website, www.cede.co.in. And if anyone wishes to provide financial support to CEDE or our student, you may reach out on our email ID, that is cede.your capital@gmail.com. Thank you. Jadin Chauhan. I now request the LiveLaw team to stop the live streaming of the event.
So thank you. Thank you.